So I'm going to talk today about the global dimensions of the law of the sea. In this context, I just want to focus on a few elements regarding the global environmental law that we saw this morning. One of them is this idea, well, you see the oceans are global commons, the seabed beyond areas of national jurisdiction are the common heritage of mankind. The high seas is open for everybody, for all states to benefit from its potential, but also those benefits need to comply with environmental protections provided by the United Nations Convention on the Law of the Sea and its relationship with other international conventions that can support that implementation. And in this light, I want to focus this presentation on the aspect of complementarity and conflict that Professor Neil Walker raised in his papers and in his book. And this idea that, well, for me, the law of the sea represents both the idea of convergence promoting and also divergence accommodating because of its evolutionary nature of the convention. So in this respect, just to contextualize, this is just an example of some of the human impacts that are happening in the deep waters. And the coastal waters are already pretty much all gone. So as humans move towards deeper waters, more and more degradation is happening due to human impacts, and those impacts are synergistic. So cumulative effects are actually higher than the sum of its individual parts. So the situation, we need to care for the global commons because those ecosystems, the marine ecosystems, also provide for ecosystem services that humans depend upon and also the most vulnerable in society. So the United Nations Convention on the Law of the Sea provides this legal order for all activities at sea. It regulates all activities at sea, if not directly or indirectly, through providing other competent organizations with the competence to, or recognizing that other competent organizations have the mandate to do their part with respect to fisheries, with respect to deep seabed mining, cabling, oil and gas exploitation, you name it. So all activities should be regulated through directly or indirectly through the Law of the Sea Convention. Also, the protection of the marine environment is an absolute obligation under the convention, and needs to be respected in that context as well. Developing states have a very heightened rights under that convention. The convention is supposed to benefit all humankind as a whole, but it recognizes that some are more vulnerable than others. And one of the things that I want to discuss today is also how the evolution of the law of the sea through different instruments, even soft law instruments, that play between national, sub-regional, regional developments can influence the evolution of the law of the sea globally. So this evolving nature of the Law of the Sea, even though the Law of the Sea Convention doesn't provide for a conference of the parties, which would be the most, expected way to have that evolution of the legal system to evolve, but it provides for a number of mechanisms through which that evolution can take place. So one of them is using best available science is included in a number of its provisions. So science evolves, and it could be incorporated into the convention through that way. The incorporation by reference, so a number of provisions of the convention, especially concerning the conservation of living marine resources in the exclusive economic zones and in the high seas, and also with respect to land-based sources of pollution, they're incorporated by reference through the agreement of parties to the convention to apply or to take into account generally agreed recommended international minimum minimum standards. And those minimum standards could be of different scales, could be sub-regional, could be regional, could be international. And we'll see some of those in just a minute. It also provides indirectly, it doesn't talk about ecosystem approach, but it encompasses the spirit of the ecosystem approach because it provides for due regard to others, to the interests of other states in the marine environment. It also provides for the limits of the ecosystem, the obligation to protect the marine environment. It also recognizes the interdependence of species and that conservation and management measures to protect certain species need to take into account the interdependence of associated or dependent species. It also provides for habitat protection. So in a number of ways it incorporates that. And then we have an implementing agreement to the United Nations Convention on the Law of the Sea that was adopted in 1995, the Fish Stocks Agreement. And that agreement even further with respect to highlighting what the precautionary approach, for example, is about with respect to fisheries and incorporates the ecosystem approach more prominently. And also, as I said before, the Law of the Sea also provides or recognizes those competencies with respect to competent organizations. So, for example, the International Maritime Organization is not explicit mentioned under the convention, but under the section on protection of the marine environment, it delegates to that specific organization the mandate to regulate shipping or pollution of the marine environment more generally. Regional fisheries organizations are also mentioned in the fisheries chapters of the high seas, and then the Fish Stocks Agreement even goes even further for developing such concepts. So in light of this, it's just the scheme. It's not representative of what I exactly think of the hierarchy of this legal regime concerning the marine environment. But if you look at that, and I'll give a few examples of contradictory views in different forums where states parties to the Law of the Sea Convention say something that states should be doing at the global level under, for example, UN General Assembly resolutions, but then at specific forum like the Convention on Biological Diversity, they do different things and vice versa. So it's just a way to illustrate that fragmentation and that way that we can interpret this convergence versus divergence in a better way. So just to contextualize again, with respect to marine biodiversity, there is a important relationship between the Law of the Sea Convention and the Convention on Biological Diversity. The Law of the Sea Convention provides for, as I said, the protection of the marine environment. It doesn't specify marine biodiversity per se, but all species are included in that. The regulations are supposed to protect marine biodiversity. On the other hand, the CBD specific, the objectives of the CBD are the conservation and sustainable use of biodiversity and wherever it occurs. And there are different mechanisms. So Article 22 of the CBD provides for that relationship. It accepts, so it's interesting that it notes the Convention on the Law of the Sea Convention more specifically. It says that the implementation of the CBD needs to respect the Law of the Sea Convention, the mandate and the obligations under the Law of the Sea Convention and the rights of states. But at the same time, it also says that the provisions of the CBD shall not affect the rights and obligations under any other international agreement except where there is a threat to serious damage or harm to the biological diversity. So in that sense, it could be interpreted as being more specific. It could be interpreted as some scholars have interpreted to prevail over the Law of the Sea Convention in that respect. But at the same time, the regulation of activities, especially in areas within national jurisdiction, are supposed to be provided by the Law of the Sea Convention. And then Article 4 explicitly mentions who is responsible for what. So in our subparagraph A, the CBD provides for that components of biological diversity per se, genetic resources, and so on, are covered by the CBD, but in areas beyond national jurisdiction, so high seas and the area, the seabed beyond national jurisdiction, the CBD would only apply to activities and processes. In principle, you could argue that activities could be regulated through the CBD, but parties have decided to not follow this path through its conference of the parties. So they decided that regulation of activities outside national jurisdiction should be done through the Law of the Sea Convention. But because it doesn't have a conference of the parties, states are still thinking about a new way to do that. And the most logical way at the moment is perhaps through the negotiation of a new implementing agreement to the Law of the Sea. We'll see that in a minute. Also, the obligation to cooperate is included in the UNCLOS, the Law of the Sea Convention, also at the CBD, especially for areas beyond national jurisdiction. CBD emphasizes that. So just to give an example, I'm going to talk about habitat protection, habitat and biodiversity protection. So under UNCLOS, Article 194, paragraph 5, specifically mentioned the need that states shall adopt measures to protect habitats of depleted species or vulnerable species, but it doesn't provide a means to do so. It doesn't provide scientific criteria to identify what those areas should be. It doesn't provide procedural mechanisms for doing that. So years later, 2008, CBD, in its decision 9/20, decided to adopt a criteria to identify areas in need of protection, and that is the ecologically or biologically significant marine areas criteria, which is very similar to something I'll address a little bit later with respect to criteria on vulnerable marine ecosystems that the FAO adopted. But still, different in practice. So the CBD adopted this criteria to identify areas in need of protection, thinking about, at the time, 2008, states were really thinking about identifying those areas to create marine protected areas globally. And they, in the same decision, they also adopted a criteria for ecological coherence of marine protected areas networks. But as time went by, states decided to, well, while it was just in theory, it was all good and sound, but as 2 years later at COP10, 2010, the CBD established a process to identify those areas based on the criteria. And of course, then states start to, oh, wait a minute, we don't want to have marine protected areas everywhere. So the concept, the origins of that criteria changed because the intention, which was to protect, became a little bit more fuzzy. And to be fair, nowadays we have described globally 279 areas that meet the EPSA criteria, and some of those areas are considered very large. They comprise different types of ecosystems. Some of them are, just in the water column. Some of them are in the seabed, and there are different types of management measures that you can apply to conserve and to sustainably utilize those resources. So there are a number of management tools to do that. So one of the areas that could, promote that more synergistic kind of approach to the EPSA, for example, EPSA as a tool, for an integrative tool for management across different regimes and across even the Law of the Sea Convention, CBD, and, for example, the Convention on Migratory Species, is some of those. This is a study that Duke University did to identify which EPSAs have been selected for the reason based on the Convention on Migratory Species some of those species are more, they're listed under the CMS, were identified in those areas because of that. So which areas are more relevant for CMS, and so on. So this is just one exercise, but an example that could be adopted by different organizations. One area that could be further investigated as well is the overlap or not between EBSAs and particular areas of sensitive sea areas that the International Maritime Organization, for example, protects. So the other criteria is the vulnerable marine ecosystems criteria, and that one was created, the first thought of it was in 2006 when the General Assembly Resolution on Sustainable Fisheries decided to impose a number of conditions for bottom fishing to occur in areas beyond national jurisdiction. And that one, I just want to highlight the importance of stakeholders in this process, for example, civil society more prominently, and NGOs, because there is a huge campaign at the time to ban bottom trawling in areas beyond national jurisdiction in the same fashion that drift net fishing, for example, had been banned through or had been the object of a moratorium in 1992, 1997, and it still is in areas beyond national jurisdiction. So there is a same movement that was pressuring states to adopt a moratorium on bottom trawling because it's very wasteful gear, it has a lot of bycatch, so other species that are unintentionally caught, and also a lot of habitat destruction. But instead of going all the way through impose a moratorium, the General Assembly decided to impose conditions. So there is a need to conduct environmental impact assessments prior to fishing, to bottom fishing, to make sure that there's no adverse impacts on those vulnerable marine ecosystems. And those so far have been identified regionally by regional fisheries management organizations, and they supply the data to FAO, to the Food and Agriculture Organization of the UN that hosts this global database, but the FAO is not actively identifying those areas. It's through the regional fisheries management organizations. But those regional fisheries management organizations also have industry as part of the state's delegation and also have NGOs as observers. So all of those actors, the interplay between those actors are very prominent in those discussions. And a lot of resistance, as you can imagine, from more fishing active countries to close some of those areas, because some of these recommendations, it's not, bottom trawling. There are a number of conservation measures that you can put in place, but fisheries closures have been identified as the most effective way to prevent damage in those ecosystems, which are mostly comprised of deep sea, cold water corals, sponges, seamounts, hydrothermal vents, and things like that. So the identification and protection has involved a lot of scientists and science, and also it is kind of bottom up because scientists and nationals from, especially developed states have been putting a lot of effort in, coming up with habitat suitability models to identify areas that could host those habitats. They have been putting a lot of effort in ground truthing that information through actually monitoring the sites to see if there is actually something there worth protecting. But at the same time, there is a lot of capacity building going to developing states with respect to learning how to do that, and technology transfer not so much, but I think it should be part of this package that could be encouraged as well. In the EBSA process, for example, the Western Africa countries were very interested in the EBSA process because they gained a lot of capacity and understanding about their own ecosystems that they didn't have before, while the VMEs are only being identified in areas beyond national jurisdiction, with the exception of some coastal states who decided to have legislation to implement the same measures or similar measures within their own waters. With the EBSA criteria, it's different. It could be anywhere. But of course, coastal states, because of their sovereign rights, can say, well, I don't want the regional workshop to identify the EBSAs to cover my water. So a number of countries have excluded their waters from that identification. But developing countries in general, with a few exceptions, were very keen to receive that because they received training on how to identify, and they're using those areas now to implement conservation management measures that they wouldn't have the capacity to do so if it wasn't for that support. So just an example I want to give with respect to that mutual supportiveness, something that went actually happen and the outcome, the implementation was actually positive, is the Sargasso Sea. So the Sargasso Sea is this, pelagic, seems pelagic, but this big mass of ocean gyre that kind of migrates. It sits pretty much on the east coast of the United States. It covers coastal waters of Canada, United States, Bermuda, but also moves latitudinally back and forth depending on the season, depending on the time of the year, and it's very biodiverse. It has endangered species like sea turtles and eels. Those sargassum. The sargassum provides a very good habitat for some of those endangered species to breed. So one thing that happened in an RFMO, a regional fisheries management organization in the Northwest Atlantic, was that after the Sargasso Sea was described by the Convention on Biological Diversity as an EBSA, NAFO, the Northwest Atlantic Fisheries Organization, was requested by two contracting parties to assess. The Scientific Council of NAFO was required to assess the impacts of their own activities on that EBSA. At the time, my guess was that they thought that there wouldn't be any impacts because NAFO pretty much regulates bottom fishing, and there's there were no regulated bottom fishing happening there, and there's this perception that the Sargasso Sea, because it moves around, it's an ocean gyre, it would be a pelagic, like a water column kind of ecosystem, not benthic, not on the seabed level. But at the time, I was actually attending the Scientific Council, and the scientists initially said, no, there's no impact. But I pointed to the EBSA description under the CBD that included two seamount chains and included Alfonsino fish species as well. So the New England seamounts and the corner-rise seamounts were included in the description of the EBSA. So that triggered a huge discussion, and then we found out that there were fisheries occurring, unregulated fisheries occurring in those seamounts, and years of discussion back and forth. Eventually, there were regulations to ban bottom trawling from those seamounts, and they adapted the midwater trawl gear to because some of the midwater trawl gears can be impactful as well, especially around seamounts, because it's very hard to control the gear. It's it's a huge gear, and they can smash against the seabed even without catching anything. But it was adjusted. There was a gear modification to protect those seamounts from midwater trawl as well. So that was a positive outcome of that synergistic interpretation. So this is the New England seamounts there. But at the same time, there are divergent approaches, and there are contradictions as well. So Elisa is just back from a meeting at the International Seabed Authority, for example, where they're discussing some exploration license from Poland that applied for exploration license in one of the hydrothermal vents in the mid-Atlantic ridge that had been described as an EBSA before. And in the recommendation of the International Seabed Authority, approving the exploration license, there is no mentioning about EBSAs whatsoever, and the International Seabed Authority has the mandate to protect the marine environment as well. As you all know, it's a common heritage of mankind. Not only, of course, there is an exploration, exploitation of mineral resources that is embedded in their mandate, but also they have the mandate and the obligation to protect the marine environment. So that's kind of and then there an angel raised the issue of the EPSA, and then some contracting parties to UNCLOS wanted to have that requirement to assess whether or not new areas that could be subject to exploration licenses are EPSAs or not, because it's not to say that because it's an EPSA, an activity shouldn't occur there, but you would be more cautious. You should take into account what kind of ecosystems are we talking about, and what kind of measures could be put in place to prevent any or mitigate any harm. And even that, that proposal that in future applications that would be a consideration was hindered by a group of countries that didn't want to have that, countries that are parties to the CBD. So it's those contradictory positions are interesting. Similarly, is also these are the gray areas there are VMEs, vulnerable marine ecosystems closures in the Northwest Atlantic, so to protect corals and corals and sponges. It's very small. So do I have a pointer? I don't know. Don't want to press anything, but you can see there's a little rectangular gray area. Here is a VME, CPAN coral area that's closed for bottom trawling on the Grand Banks, but it's an extended continental shelf of Canada, and Canada issued a drilling license, those yellow crosses. They're right on the top of a closed vulnerable marine ecosystem. So it's closed for fisheries, but it's not closed for oil and gas. And there we see also those tensions and the power and the trade-offs, but also the power imbalances, because oil and gas usually trumps any fisheries interests and so on. So at the same time, we have that, at multiple levels, even to close those areas to fishing is a big battle, because you need to take into account of course, the socioeconomic issues, but usually those areas are not fished anyway. It's too deep to fish, but they eventually agree with the closure, and then we have another sector kind of trumping the protection that measure provides. But so interesting in response to that. So, and it's extended continental shelf of Canada. Of course, they have sovereign rights. They can do whatever they want. But also, at the same time, there are, impact assessment obligations and information sharing under the Law of the Sea Convention that it's disputable whether it was followed correctly or not, but they have done impact assessment, but the information sharing with the competent fisheries organization wasn't the best. And right after that, in the same year, in response to that situation, the General Assembly Resolution on Sustainable Fisheries, of course, another party, UNCLOS, promoted that paragraph that was adopted, saying that in vulnerable marine ecosystems areas that meet that criteria, they should also take into consideration other potential activities that can impact those ecosystems. So that was just adopted in 2016 and in December. So I'm not very hopeful that it will move, that it will be fully implemented. But the good thing about VMEs is that under the UN General Assembly resolutions, they're assessed, the implementation of those resolutions and those provisions are assessed every so often, every 5 years or so. So that's also a way to push for further implementation, something that other provisions or other paragraphs of those resolutions don't have that traction because of the lack of monitoring and reporting procedures. So again, because of this, lack of those controversial or conflicting interests and conflicting uses of the sea, in 2015, the United Nations General Assembly recognized the need for a new implementing agreement, at least with respect to the conservation and sustainable use of marine biodiversity in areas beyond national jurisdiction. And they decided to develop this international internationally legally binding instrument to promote further coherence in the regime. And but at the same time, it also recognized that this new instrument should not undermine the instrument and process that it created under that resolution, should not undermine the other relevant frameworks and processes and so on. But what we have been seeing through this, 2 years of PrepCom preparatory committee discussions in the past 2 years is that they oftentimes try to protect the interests of, groups like fisheries or deep seabed mining and so on, but they forget oftentimes of the obligations that the Convention on the Law of the Sea and the Fish Stocks Agreement, for example, provide for, the implementation of an ecosystem approach and a number of other things that in the discussions kind of seem lost. So it's important to emphasize that if they want a coherent regime, we need to take into account those broader obligations as well. This is still going on. The PrepCom, the preparatory committee, has recommended that the General Assembly take a decision as soon as possible. So we're waiting for, there are some states sponsoring the resolution, and they're still discussing this year. Hopefully it will still be adopted this year so that an intergovernmental conference can start to negotiate the actual agreement. But that's only with respect to areas beyond national jurisdiction. Another attempt to kind of consolidate consolidate the implementation of those obligations, not only with respect to the law of the sea, but also integrate other components, social and economic components, is the Sustainable Development Goals. They're not legally binding, but a number of efforts, there's a lot of effort put into the implementation of the Sustainable Development Goals. And the recent COP 13 of the Convention on Biological Diversity, in its Conference of the Parties in December last year, adopted this resolution on mainstreaming biodiversity also into the SDGs. So that's another form of integration between different frameworks. One way to do that, Elisa and I, and Mara is very involved in this special issue on synergies across SDGs, Sustainable Development Goals. One of the arguments we have in one of the articles we wrote is that, for example, the target around protected areas of the SDGs is very thin, very weak, and the complementarity provided by the CBD Aichi biodiversity targets that were agreed in 2010 and they're due in 2020, are more comprehensive, are more complete, and should be integrated. That's one way of mainstreaming biodiversity into the SDGs. Of course, that's just one example of one target and another target. And the CBD target actually goes further in talking about equity. So it considers like local communities, it considers the need for ecologically coherent networks of marine protected areas, but also other effective measures. So these other effective measures are not fully fledged MPAs, but it could be, for example, VME closures. It could be adjustment in the fishing gear, for example. So those kind of things are more comprehensive. It could find a home in the Target 11, something that Target 14.5 of the SDGs don't provide very well. And then just I couldn't as part of the Aichi Target 11 as well, they also say that this comprehensive network of marine protected areas and other effective measures should be integrated into the seascape. And this integration into the seascape has been interpreted, actually was promoted during COP10 with basis in documents suggesting that integration should be done through the application of the ecosystem approach. And just in COP13 as well, we saw a decision specifically on marine spatial planning, recognized that marine spatial planning is a participatory tool to facilitate the application of the ecosystem approach and expedite the progress towards the Aichi targets that I just mentioned in marine and coastal areas, including through linking marine spatial planning with marine protected areas, other effective measures, impact assessments, and so on. And in an article, also part of the special issue that Mara, Donna, and Elisa Murgira have suggested that this integrative tool could enhance the synergies between the SDGs, different SDGs, and the SDG 14, because it's also part of the rationale between the SDGs when they're adopted is that they're not to be implemented in silos. They need to be integrated because of this, mutual supportiveness, I think that we need to have, and this broader understanding that we need to have across different range of issues. And at the same time, they're universal targets, so they're not only, focused on developed countries like the Millennium Goals used to be. So in light of this, just to conclude, I don't have the answers, but I think, I was very inspired this morning by the theoretical part of this symposium. And, while I'm more aligned, I think, with the notion that that link between global environmental law, global justice could lead to a more, the compositive and the compensatory kind of approaches. I think in this context, it would fit well. But I think this broader understanding of the different species and the different terminologies can help can shed light into those complexities of the practice that we're experiencing on the ground. One of the things that a project that Elisa mentioned that we are working on, the Marine Benefits Project, we're looking into human rights law as well, the right to food, and linking ecosystem services with, as a bridge to link this protection of the marine environment and the support of the right to food and support of sustainable livelihoods of small-scale fisheries, for example. So, I think there is a lot of scope for further integrating and investigating tools like environmental impact assessments. For example, we've done correctly, and in an integrative manner to incorporate those procedural and substantive requirements that currently exist, but they're dispersed in international law. And through that, I think global environmental law can provide those necessary linkages to solve those, but I still don't have the answer, so hopefully Neil can help me with that as we move along. Okay, that's all for me. Thank you very much.